Good evening. Welcome to the Veterans Voice. This is your host, Amanda Manier. I am the managing attorney at the Veterans Law Group and a veteran advocate. And we have been, if you're first hearing us, we're here every Tuesday night from 7 to 8 o'clock. And we are live this evening. Would love to take your calls if you are a veteran out there who is navigating the process of the VA disability claim. That is exclusively what our firm does and has been doing for over 25 years. So I may not know a lot about a lot of things, but I know a lot about this subject. Kind of started working with the firm about 9 years ago and kind of got thrown in the deep end. So if you have questions about your claim, our number here is 800-222-5222. A little bit about us. Like I said, we've been practicing exclusively in the area of VA disability compensation for over 25 years, and I get the joy every day to work with not only veterans in my office and family members of veterans, but also every single one of our clients is one of those as well. So it's one of the things working in the legal field that it's really nice to know that every one of our clients is deserving of what we're pursuing for them. So essentially what we do when we are representing veterans, we only work in the appeals department. So that means you have to have received a decision from the VA and something that you're not necessarily happy with, or maybe you were non-service connected, they denied your claim, or underrated. And underrated meaning they're not giving you the percentage that they should have been giving you. Or if you just like somebody to take a look at your decision and make a decision or help you to make a decision as to whether or not it's something that you should pursue in the appeals. So that's part of what we do, and we do offer free consultations on our website, veteranslaw.com. Or like I said, you can join us every Tuesday evening here. Just listen in, maybe get some information here, not only in responding to questions for people who call into the show, but generally what I do is each week I pick a topic or two, something that has generally come up over the last week or so, and things that I feel like would be maybe educational and supportive for those of you who are handling your claim on your own or working with a veteran service officer, just want to know a little bit more about kind of what the system is and what the best way, the strategy-wise. I always look at things as it's not just a matter of what the letter of the law says, but what's the best way strategically to get your case granted and get your case through the VA system, hopefully without it turning into years and years. But as the VA is a large bureaucracy with a lot of red tape, sometimes cases do take years, and often they do. So tonight, what I wanted to do, and again, our number here is 800-222-5222. If you have a question that is not related to the subject matter that I'm about to talk, feel free to give us a call. When I get a break, I'll definitely take your call and see if we can help you with your specific question. But a couple of the things that have come up over the last year, the last week or so, is specifically related to, two things. First is PTSD claims. When there is a PTSD claim, so that's post-traumatic stress disorder, that is one of multiple different types of psychological conditions in which you can pursue a claim with the VA. And one of the big, not necessarily mistakes that a veteran makes or a veteran service officer makes, but it's just a matter of this might be a better way to handle it instead of filing just exclusively for PTSD or just exclusively for anxiety or depression that maybe you were diagnosed with by your doctor or being treated. You want to look at it from a bigger perspective to give the VA the opportunity to look at multiple conditions that you may have. For example, PTSD is one of those that shows itself in different ways in different people. So as part of law, they try to make things very narrow and as specific as possible. So in some previous episodes, I think it was 2, maybe 3 weeks ago, we went through, and you can listen to any of our previous episodes on the 790K ABC website or going to our website and clicking on podcasts. So if you're interested in digging into a little bit of that, we went through symptoms of a psychological condition and what would get you a 50% rating versus a 70% rating, that kind of thing. Unfortunately, as I mentioned on that show, the VA looks at all psychological conditions, whether it's anxiety, depression, PTSD, bipolar, schizophrenia, adjustment disorder, any of those psychological conditions, the VA looks at all the same. And what I mean by that is they look at their list of symptoms that are listed in their criteria, and they say, okay, which of these do you most likely fit in? So you don't have to have every single symptom in the 50% to get 50 or the 70, but it's kind of a weighing test. You have more in the 70 versus the 50. And there's a couple of things that I'm going to post on our social media, and I will also, in our social media, you can reach us on Facebook, Instagram, Twitter, all of those above, by searching veteranslaw.com. I do often get questions submitted there, and throughout the week, I'll respond to the questions throughout the week, but they also sometimes generate questions for the radio show here and subject matter for the radio show. But I'll post within our social media this week a couple of things. One is that symptoms list. It is also on our website, but just if you want to be able to refer to that, and I'll pull the episode that we got into pretty heavily on what those symptoms are and what you have to prove. Today, what I want to talk a little bit more about is diagnosis. So as I started to mention, I get a little frustrated with people who have a bipolar condition are going to have different symptoms than somebody who's having depression or anxiety or PTSD or schizophrenia. The VA tries to, again, lump them all together in a single rating, and it doesn't always fit. So how do you navigate that if you have a different diagnosis? So when I'm evaluating cases, generally in our office, a veteran will come to us. They usually go to our website, fill out a consultation request. They get scheduled and set up with the time with one of our team who, one is a military wife herself. She's very familiar with the process and watched her husband go through it, but she will, ask you questions about your condition, your symptoms, and then look at the rating decision and send all of that to me. So when I get a rating decision, I'm always looking at, okay, one, what is the veteran looking for? What is it that they want to accomplish with this appeal? And then what's the missing piece for it? So as you've heard me say many times, but I believe in repetition, it's how we retain information, is that you always have to have an in-service stressor, a current diagnosis, and then a link between the two. So if we're looking at just PTSD was probably the one that we hear about the most, they're looking at whether there was an in-service stressor. So if that could be non-combat or combat related. The good thing is if it's combat related and you were in a zone with combat where there was a fear of hostile military or terrorist activity, the VA will what they call concede your stressor. So you don't have to explain to them specifically what happened. They will just say, okay, we presume that you were in this type of environment. You probably had a stressor. If you're non-combat, they will ask you to explain your stressor. So if your stressor was a training accident that you were in, or, a fear of, you didn't have a parachute open when you were doing training exercises, something like that, then you have to show them, you have to explain it to them when it was, where it was, to the best of your ability and knowledge. And then they will go and try to verify that stressor, where a PTSD combat-related veteran doesn't have to do that. All of the others that are non-PTSD, anxiety, depression, schizophrenia, bipolar, adjustment disorder, all of that, you have to be able to show that you had those symptoms in service or within 1 year following your service. So it's really important when you're looking at years later. If I'm looking at a Vietnam veteran and the VA denied PTSD because they said no diagnosis of PTSD, they may then go ahead and concede another diagnosis, which might be like anxiety, depression, one of those, or alcohol use disorder or substance use. I immediately look at that as, well, those are symptoms of the PTSD, so I know I can probably get a PTSD diagnosis utilizing some of our private doctors that we work with. So those are really important when you come back to just looking very specifically at what's missing in that. And I've seen over and over again lately a denial for lack of diagnosis, whether it's PTSD, anxiety, depression, any of those. And as I mentioned, I just want to remind you guys that I'm happy to take your calls live this evening. Our number, as a reminder, is 800-222-5222, or if you want to jump on social media, if you're out there doing that, Facebook, Instagram, Twitter, you can just post a question there or send a private message if you don't want to post it publicly. I'll see if I can get to those this evening. But going back to before we go into the break, I just want to kind of introduce a little bit of what I'd like to talk about. And this might be a lot of content heavy this evening. So if you want to kind of go back and listen to this again, maybe when you're not in your car, you're sitting down, and you want to look at, okay, I was denied for lack of diagnosis of a PTSD. What should I do about that? First of all, as you will hear me harp on all the time on this show, don't do this alone. If you are trying to handle your claim alone, or if you're going down and trying to depend upon the VA employees, if you're going down to like the regional office, depend on them to help you with your claim, I would highly caution that. Reach out to, if you're filing your new claim, reach out to a veteran service officer all over California. If you're in California, every county in the entire state of California has veteran service officers that will support you and to help you file your claims at no cost to you. They don't necessarily, some of them, there's some really great ones out there that they really kind of take on the ability to advocate for your case. But in general, most of them only have either the knowledge or the time, really honestly, to, file the paperwork, tell you what evidence you need, and submit that paperwork for you. It is not for lack of sometimes even knowledge or trying. It's just they're overwhelmed. They are very, very busy. So once you get a decision, like I said, you're more than welcome to come to our office or reach out to, a law office at that point to help with the appeal. But one of the things I wanted to get to when we come back from a break is going through a little bit of I'm looking at what's called a disability benefits questionnaire. And when you file a claim with the VA for any condition whatsoever, and they see enough in your service treatment records that would trigger an exam, their requirement it's called duty to assist you with getting a proper diagnosis. Was it related to your service? How severe is it? You're going to get scheduled for a comp and pen exam, often referred to as a C&P exam. And then at that point, when you get scheduled for those exams, the examiner, who should be in the medical profession, sometimes you're just working with a physician's assistant, sometimes you do get scheduled with an orthopedic specialist or a psychologist. All mental health is supposed to be with a psychologist or a psychiatrist. So you shouldn't be being scheduled with a physician's assistant for a psychological condition. Can't say it's not happened. I've seen stranger things happen. I was just talking to somebody in my office today who he got scheduled for a sleep apnea exam, and when he got to the office, the specialty of the examiner was gynecology, which is very interesting. Obviously, we challenged that. We wouldn't have challenged if it was a positive exam. It was a negative exam, so we challenged that. But when you get assigned for a psychological exam, not only should they be scheduling you as somebody who we know is competent, but also they have started listing why this person has a competency in order to do this. And we're about to go to a break, but when we get back, I'm going to touch on two things. One about the MST, the military sexual trauma, which is very specific, and then also the difference between combat and non-combat when it comes to an examination. This is Amanda Manier. You are listening to The Veteran's Voice here on 790 KABC, or you're listening via our podcast as well. If you're listening to this a little bit late, we are discussing VA disability compensation claims. If you are a veteran or a family member of a veteran that would like to ask some questions about how you can work through the VA, maybe just some advice, some strategy, as we always look for it in the legal field. This is all our office does, is VA disability claims. Before we went to the break, I was mentioning that we are taking your calls live this evening, even if I have a topic that I'm talking about and you have something that's different, I'm more than happy to take your claim. It's more important for me to make sure that this time serves you as a listener. And at the same time, being able to provide sometimes some pretty heavy content for, if you're listening in, you can always re-listen to our show that's posted on the 790 KABC website, as well as our website, veteranslaw.com. If you're sitting down and you're about to work on like an MST case or a PTSD case, whether it's your own or veteran service officers who are out there listening. I've spent years traveling all over the country. That's where I will be next week, teaching veteran service officers a lot, again, is strategy and also education of how to be a good advocate for your clients. Things that we see the VA, because we're handling, we carry about 1,000 cases right now, and we see all kinds of things, and then we start to see patterns in mistakes that the VA is making, and how we're approaching them to kind of help make a difference with that. So, before we went to the break, we were talking a little bit about what happens when you file a claim for a psychiatric disorder, whether it's MST, PTSD, any of those, and what you're going to have, kind of experience when you're going to go into a CNP exam. So I want to talk a little bit about strategy of that. But before we dive into that, we're going to take a call here from Lieutenant Colonel Martin. Lieutenant Colonel, welcome back to the show.
Hello, and thank you so much for your expertise. We really appreciate the technical details and you getting down deep. And this is coming from a lot of veterans, and I talk to them every day, every weekend about. So thank you on that. And then I wanted to just shout out to Daryl. He's called in from the Veterans Voice from the VA over at Long Beach. They have they meet often. And then a big shout out to the U.S. Army Reserve here in Orange County. We have the second largest in the United States right here in Orange County for the listeners. And we talk about this all the time. But anyway, I had my comments on your PTSD was 30% one time or less panic attack, 50% more than one panic attack, 70% near continuous panic, and then 100% total, and they've not come back from Afghanistan yet. They're here on the home ground. But anyway, that wasn't my question. It was on revisiting your earlier effective date you spoke about over the last few weeks. And I just wanted to run something by about interim earlier effective date. So the facts were 11 years ago, 2011, was an award of 100%. However, the claim was submitted in 2003, returning from Afghanistan. So during those years, a lot of the claims were denied, even with U.S. Army LODs, line of duty proof of the claims. And the VA granted 10% and some back pay for a little bit of the time from 2003 to 11. But the VA review officer was negotiating with, hey, we'll give you 80%. No. We'll give you 90%. No. We'll give you 100, permanent and total, but your back pay will only be for a couple of years instead of all the way back to 2003. And that was my question about your interim. Even though I've already, there was already 100% disability for 11 years, and there was, and so anyway, I wanted to say thank you very much, and I'll listen to your expertise on the PTSD, which, by the way, is the most talked about and discussed subject with my fellow veteran friends, and many of them who had the claim of one or more panic attacks per week, the measuring unit in time, they were the ones that were at 100%. And I just wanted to bring that mathematical numbers out because I'm a numbers guy. Okay, thank you very much. I'm going to hang up and listen to your expert guidance. Thank you.
All right. Thank you so much for the question. It is not an uncommon situation. So one of the things that I will say is if a veteran service officer is negotiating with you over what you should get and not get, and they're like, oh, well, how about this? Is this okay? And how about this? That is absolutely not what they should be doing. They should be looking at the facts of the case and the evidence that's submitted and granting the effective date based upon what the evidence is. So some of the things that I see in a situation like this, where if a claim was filed in 2003 and they initially were granted, a 10% rating, and then I get a case and it's somebody coming to me with now they gave them 100% back to 2011. I'm sorry, 10% at 2003. And now they come back and say, okay, well, we're going to give 100% back to 2011. My initial reaction to that is, okay, I'm going to go in and look, did the case stay open that whole time? If from 2003 to 2011, the veteran was regularly appealing and keeping the case open, if it was in legacy appeals, that's where it would be. If they were submitting additional new evidence that the VA was not considering, I'm looking for any reason why I can argue that case was open that whole time. And then what happens is it was open that whole time? Okay, so probably the most common case that we quote to the VA is the case called McGrath. And what McGrath, and the VA gets this wrong all the time. And it's just it's a nuance in wording that I think that they just, somebody might understand and somebody may not. But McGrath says that the percentage rating and the effective date, so it should show based upon when the medical evidence supports that higher rating. So what the VA does all the time is they may not get that evidence until 2011 for whatever reason. And so they say, well, the medical evidence shows in 2011 it was that increase. But maybe they had those increased symptoms all along. It's just that they date it based upon like the date that there was a doctor's appointment or the date that they received evidence. So when we go in and do an independent medical examination, we specifically ask our doctors that we work with to be very specific about the fact that these are the veteran's symptoms. This is what he's been experiencing, including those panic attacks you're talking about. And it appears that these symptoms have been at this high of a severity going all the way back to 2003. So now the medical evidence in the record is showing those symptoms go back to 2003. And even with that, I'll tell you honestly, the VA messes that up all the time, and they grant the 100% based upon our independent medical exam date. So then we file an appeal on a McGrath, and we argue, no, there's clear medical evidence to support the fact that those symptoms go back that far. It's not the date of the medical evidence. It's the date the medical evidence shows the severity of symptoms. So we work on that all the time. And I will be truly just honest with you that sometimes in cases like that, you'll hear me say all the time, if you're a VSO listening to me teach, some cases you just have to take to the board. I know veteran service officers, VSOs, a lot of people don't like taking cases to the board because it takes a long time to get there. But the veterans law judges at the board have a lot more discretion. They're not bound by the M21 adjudication procedures and manuals. They tend to be a lot more soft-hearted. Listening to the Veterans Voice, my name is Amanda Manier. I'm the host here every Tuesday evening from 7 to 8 o'clock. And we spend this time talking about veterans and how they can kind of help work through the process of getting their VA disability claim. I am the managing attorney at the Veterans Law Group and a veteran advocate. It's all I do for a living. I love it. It's while I often refer to the fact that I have a bruise on my forehead that's permanent, dealing with a VA every day, it is a joy to be able to work with veterans and to help those people who are truly in need and truly deserve what we are pursuing for them. We also work with a lot of family members of veterans, whether that's because the veteran has moved on or moved on to a better place, hopefully, or sometimes it's just easier for the spouse to communicate with us on behalf of the veteran, and as long as he or she gives us permission to work with the spouse to get the evidence that's needed, kind of help with what the process is, we definitely do that. So if you fit in those categories, and you'd like to talk about your claim, we are taking your calls live this evening, 800-222-5222. We do often also get contacted directly when we are not here on Tuesday night about people listening to the show. I know it can be sometimes uncomfortable to maybe talk about your disability claim publicly, but we do offer free consultations. Our website is Veterans Law, that's veterans with an S, law.com. Our number is 888-811-0523. You can reach us 5 days a week, 8 to 4, or leave messages, and we'll have a great team, an awesome, great team that can get back to you and see how we can help you. Before we went to the break, we were kind of answering some questions for call-in about specifically related to psychological disabilities, whether that is PTSD, anxiety, depression, any of those, and how it kind of intertwines with an effective date. I've talked on this show a number of times, and if you're ever interested in listening to some of our early shows, you can find those at the 790 KABC website or on our website, veteranslaw.com. And I often bring up the issue of effective dates because it's quite frankly one of the questions, or one of the issues or mistakes, I should say, that I see the VA making on a pretty regular basis. Cynicism in me says intentional, so they don't have to do it, but the rest of me says I just don't think that they're properly looking at it. And obviously we as representatives have the incentive to do that. So we were talking about a case where it was an increase as of 2011 to 100%, but that case had been filed originally in 2003. It's been granted a 10% rating for PTSD, and they ultimately gave it to him in 2011 at 100%. So just a little bit of a reminder of, when we look at a case like that, if I talk verbally to the veteran and I find out that the severity of his symptoms, including things like panic attacks, suicide ideation, inability to establish relationships, things like those that fall within those symptoms, I'm going to, I can go to a psychologist who will do an interview with the veteran and render an opinion that those severity of his symptoms didn't just magically start when they went to an examination in 2011. It's that they've been there present along the way. And one of the things I wanted to touch on before I take the next caller is what's really important about that is most of the time when I see a low rating like that, and then I have a conversation with a veteran and their symptoms are so much higher, I always ask about the examination that they went to that gave them that 10%. Most of the time, I would say probably 90% of the time, if not higher, the veteran did not feel comfortable speaking with that examiner. So if you think about it, when you get scheduled for an examination, you get called in usually with very little notice to talk to a complete stranger you've never met before about how you are on your worst day when you think you might want to kill yourself, or you are throwing things around or getting in fights in traffic. It's like the things that you don't want to admit about yourself, or that you don't, it's hard to talk about even with your spouse. You're supposed to talk to a complete stranger about that. And generally it's 20 to 30 minutes at the most. And that's usually the majority of the time. So I can address those issues. And really anybody as a representative should be able to address those issues with the VA of they didn't feel comfortable going to this exam. It was bad timing. Sometimes people like to take their spouse with them, or a family member who observes how things are on their worst day and can help kind of support that. And we've heard that the VA just flat out turns it down, says, no, you can't bring this other person in. So there's all kinds of reasons to look at a bad examination and how you kind of attack it. In addition to, in our field, we can get independent exams to help support that. So I hope that that's helpful. I did want to take the next caller here. James, welcome to the show.
Yes, hello.
Hi,
hello?
I hear that you've been... Yes, can you hear me?
Yes, I can. Yes, ma'am.
Okay, our screener was saying that you've been... I can hear you great, yes. Our screener was saying that you've had multiple declines or denials from the VA over years. Is that for a PTSD or mental health in general?
No, it was for injury I sustained while on active duty in the military. I was drafted in 1968 into the United States Army. I became a platoon sergeant. I did my very best that I could possibly do. I submitted it back. I got a bad infection in my feet, which I told them before I went in I had a foot problem. I brought a note from the doctor showing that my feet were in bad shape. They tore it up in front of my face. and said, just follow the yellow line. Your uniform's already made for you. So I did the very best I could. I became platoon sergeant. I was very good in the service. I got an infection due to the vigorous training and running and jumping in my military training, and it became infected. I had to go to the hospital. The major that saw me at the end, I had been going to the sick call every time, and they fed me morphine and Darvon, and I got sicker and sicker. Finally, my infection was so bad that I finally made it to the hospital, and the major that saw me there, he said, "Oh, my God, son, how long has this been going on?" I told him, and he says, "Get in my office," and they ended up discharging me with an honorable discharge due to the fact of my feet collapsing. And my arches and my ankles were gone. And so I've been having problems. So once they discharged me, my whole life, I'm 75 years old, I had been applying and applying. They just keep turning me down. They took me from my civilian life into the military life. I was drafted. Yeah. I did my duty. I served my country. I did the very best I could. I made platoon sergeant. I was in charge of 44 men. You know, I did the very best I could. I got sick due to their training on my feet and the abuse that they gave me on it. And I've been turned down 6 times now, and I keep applying and applying and applying. And all I get is a denial.
Okay, James, so I'm going to say a couple things here. First of all, I have a huge heart for veterans who served in the era in which drafting happened, Vietnam, earlier than that, and especially when it comes to injuries and whether it's physical or mental health, because you didn't ask to go. You didn't volunteer to go in. You were called to serve your country, and you did it whether you wanted to or not. So, so big thank you to you for showing up and doing that and doing the best that you could under the conditions that you are in. When it comes to being able to help you now with this, it always comes back to the question of why did they deny you? There's those, it's a formula. It's A plus B plus C equals disability. So A is in-service injury, B is current diagnosis, and C is a link between the two. So when you're getting just a flat-out denial, and I assume that's what you're saying, they just won't give you even service connections. Not that they're giving it to you and giving you 0%. They're just not even acknowledging it's related to your service.
They're just saying denial. But I've been through their examinations. I've been through it even recently within the last few months. And one of the letters that I have from them saying, it's come to our attention that it's a possibility that because they sent me to a nurse practitioner for an examination. Didn't even know what my case was. I mean, it wasn't very, good. And the next thing I know, after 3 or 4 weeks later, comes this denial letter again. And I had applied back in 2000 or 2003. And each time, before that, I went to several different military people, and they said, "Well, we've only been in a few months, so you're not going to be able to be eligible." Because I was in the service in my training from February the 7th to April the 2nd. And in that period of time, they totally destroyed my arches, and my feet have been in agony ever since. And
is
from
there
my
anything...
feet now I have knee, hip, and back and neck problems that have been noted by 4 different doctors who wrote me letters stating so.
Okay. So the first key is getting the feet. Then those other things become secondary conditions. So biggest hurdle is the feet first. It doesn't mean you can't file for all of them at the same time. But what I'm getting into is, so when you get a decision from the VA, it'll tell you, especially now, you'll find, in your letter, it's usually the back couple of pages that will say favorable findings if there's any. So favorable findings might be you had an in-service injury, so they've acknowledged that. Or favorable finding might be you have a current diagnosis. So out of that formula of A, B, and C, which one of them, if any, are they acknowledging? Then we just have to find the missing piece. And if the missing piece is there's nothing in your service treatment records, which it sounds like there should be if they're sending you for an examination, Then the question is whether the opinion from the doctor that you went to is you don't have a current diagnosis, or they don't believe that your current foot disability is related to your time in service. It might be something different. And so
he
that's
mentioned on that he could not diagnose it. He could not say that this was caused by the military. Well, my gosh, I'm 75 years old. This happened when I was 20. And I've been suffering with it ever since, but I made several attempts to contact the military, including the representative from the VA, who seems to have not helped me much at all. And, she said, well, you have to be patient, Mr. Baracchio. I said, I've been patient since 2000. I'm 75 years old. What do I have to wait till I'm dead?
Right. And here's what I'll tell you is I'm imagine that you've never actually appealed it like up to the board. Is that correct?
No, I did. I sent one appeal after another appeal and so forth.
Okay, so James, let's do this.
Paper. In fact, I was asking where your law firm is that I might come and talk to you.
Well, we work with people all over the country, but we do it all over the phone. So go to our website at veteranslaw.com or call us at 888-811-0523. You'll talk to Karen or TJ and let them know you talked to me on the radio show, and we'll see what we can do for you.
All right, that's 888-811-0123?
0523. All the other numbers you got correct.
Okay, 811-0523.
That's correct.
Ma'am.
We'll see what we can do for you. Okay? Hang in there. This is Amanda Manier. You're listening to the Veterans Voice here on 790 KABC. We are talking with veterans and their families about VA disability benefits, and most likely not just talking about them in general, but kind of how to navigate the process dealing with rejections from the VA or denials from the VA or under ratings from them, or how you can maybe better approach your case. When I do interviews all the time about what we do, one of the biggest questions that I get is, why are there's so many issues or so many veterans that are denied by the VA? I think the last statistics I saw was between 70 and 70% of all initial claims are denied. And that doesn't necessarily mean the entire claim is, the entire case is declined. It may be that you claimed 5 issues and 3 of them were declined and 2 were granted. And so they look at it issue by issue. So that's disability by disability. And it's so high. And it's like, well, what is it that is, what causes that? And, I can only speak from my experience. I'm, I guess I have a hard time saying I'm an expert in this, but I suppose I am. But it's my experience in this is a couple of things. It's usually one of a handful of things that happen. And so before we went to the break, we were talking with James about having he's filed 6 times for this foot claim that he was medically discharged effectively for years ago. And unfortunately he was drafted and he served his country to the best that he could, but he had a, foot injury that he ultimately ended up getting discharged for. So when I'm looking at a case and I'm trying to figure out, what is it that is the missing piece here? One is that I often think that veterans initially going into the process have a certain amount of trust. The VA is set up as an entity to help veterans. It's supposed to be a non-adversarial process. And what I mean by non-adversarial, it should not be the VA against the veteran. That's not, when you go into a courtroom, it's, if you and I were going to courtroom and I was your representative and we were wanting to sue the government for something, we go in there and they have their attorney, we have, I'm your attorney, and we would fight over it. And the judge issues a decision. That's an adversarial process. Both parties have representatives and 2 arguments are being made. When it comes to the VA, as a non-adversarial process, the VA is supposed to look at all of us coming together. If you think about it more like a mediation or a discussion, is sit down and say, okay, here's the veteran's claim, here's the evidence, here's what the law says, and this is why you should grant the case. And I look at my job as I need to put all the ducks in a row and make it easy for the VA to grant the case. So when you hear people call in on the show, I'm always going to ask, well, why did the VA deny it? And it sounds like, if you were listening prior to the break, it sounds like what James was saying is they weren't denying that he had an in-service foot injury, because they did send him for exams, that kind of thing. But it sounds like the examiner is saying that either he doesn't have a current injury, which is probably not the truth, or his current injury is not related to service. And the longer you get away from service, the harder it is to connect that injury to service. So orthopedic issues are one that is very common, where, you know, you might have had a back injury in service and that was 20 years ago, and 20 years later you're filing a claim. And we're always going to look at, or the VA is going to look at, well, what else happened in the last 20 years that could have caused this injury? Were you in car accidents? Did you work construction and hurt your back? You know, why is it that you're relating it to this injury in service? So they ask a medical professional, can you connect these two things? It's often called a nexus letter. Can you provide a nexus between the current injury and the time in service? And not to discourage those people who've been out for a while, but those people who are either listening in that are just getting out of the military, maybe in the military now. I hear all the time people don't want to file a claim because they're like, oh, I don't need it. It's not that bad. As time goes on, things like orthopedic issues generally do not get better. They usually get worse. And if you file your claim early on when you get out of service, even if they grant service connection at a 0%, the VA is already acknowledging that you have a back injury related to service. Then later, all you're really doing is arguing symptoms of that it's gotten worse over time, and they might give you a higher rating for that. If it's been a long time, like our caller James before, from the time that the injury happened to when you filed, those are not insurmountable issues. And when I was asking James about if he's ever taken the case to the board, when you go up to the board, so in the appeals process, it's internally, there's two different, when you get a decision, there's two different options right now. There's two different options within the VA to get a decision. And then outside of that, you file to the Board of Veteran Appeals. It's in Washington. The judges there are administrative judges. They are trained lawyers. They have a staff of lawyers and a staff of just people, but people who are educated. And I use the word lawyer because what we're taught as lawyers is to take a set of facts, take the law, and make some sort of reconciliation between that. Apply those laws to the facts and make a decision. And that's effectively what's happening at the VA when the veteran service raters or decision review officers or higher level reviewers, whatever they're calling them these days in their title, that's effectively what they're doing, but without the education to do it. So while it takes a long time to take a case up to the board, I prefer to practice at the board because I feel like I'm talking to people who are educated in what needs to be done. But in addition to that, it's outside of the education. They have a lot more flexibility because they have, I think, the background that they have. People at the VA, they are bound by their policy manual called the M21 adjudication procedures, yada, yada. When it goes up to the board, those adjudicators, those veterans law judges have a lot more discretion in what they can or can't do. They have to do it obviously under the law, but they can make certain judgment calls about, if James went to the board and told the judge what happened to him in service, he sounds to me on the phone very credible as to what happened to him. You become a real person instead of the VA just reviewing a file with words and medical evidence and all that kind of thing. So that's why I say, and I said before, that when I'm teaching veteran service officers, sometimes it's literally just, you know what, sometimes you got to take a case to the board. You're not going to get it granted at the VA level. But one of the things in our office, our last couple of minutes here this evening, in our office, in the room that I'm sitting in, where I'm, have set up kind of the podcast radio studio, we have 4 bulletin boards on the wall, 2 of which are completely covered in wonderful notes and thank yous and pictures of our clients and, American flag that somebody sent us with, I don't know, it's beautiful. It's the happy wall. And it warms my heart when I'm dealing with frustration with the VA or, realizing that, it sometimes, like, 2 years ago, we won a case that the veteran had been fighting for 20 years with the VA, and he got a little over $500,000 with the VA. And that was, obviously awesome, but it's also sad at the same point because the veteran had to fight it that long. He shouldn't have had to do that. But it was one of those cases that took him a long time to get service connection. Once they gave it to him, they only gave him like 30%. Then we fought for 50 and all of that kind of thing. So it's uphill battle, and that's great. The other boards that we have are what we, jokingly, affectionately, whatever word you want to use, refer to as the VA wall of shame. And it's just ridiculousness sometimes that comes out of the VA. And after doing this for as long as I can, I often say that, nothing really surprises me out of the VA anymore. So things don't, for me personally, get put up on that board out of my office. But very often, because it takes a rare thing for me to be surprised, but every once in a while I am. And I'm looking at two things on that board that I just want to share with you. One is a single piece of paper that's completely blacked out. Like it's almost like somebody took a copier to a black construction paper and made a copy of it. And we got that in an envelope with nothing else in it. It was addressed to us and there was literally nothing else in it. The last thing I'll share with you is regulation, specifically in the regulation about the attitude of rating officers. This was written in 1976. It's in the law. And it states, it is to be remembered that the majority of applicants are disabled persons who are seeking benefits of law to which they believe themselves entitled. In the exercise of his job or functions, rating officers must not allow their personal feelings to intrude. And it goes on to talk about how fairness and courtesy must at all times be shown to the applicants, and nothing personally should be indirectly or directly personally inserted into this. So again, going back to non-adversarial process, I have this on my wall, and I have regularly reminded people at the VA this is what they're responsible for abiding by. We're wrapping up this evening. It was great to be with you. We will be here next Tuesday, 7 to 8 o'clock. This is Amanda Manier with the Veterans Voice. Have a great week.